Hello there. Today we're going to be talking about the lemon car laws that cover a lemon motor vehicle in Hawaii. In Hawaii, there are four different lemon car laws. The first is the Hawaii Lemon Law itself. The second is the federal lemon law called the Magnuson-Moss Warranty Act. And then the third is the Hawaii Commercial Code that also covers motor vehicle sales. And then the last one is the Unfair and Deceptive Act statute that Hawaii has. A very powerful law all on its own. Any one of these laws can apply to the sale of a defective motor vehicle. Sometimes you're far better off to use all of them or to pick and choose depending on what it is you're trying to get accomplished for your client, or if you're a consumer, what it is you're trying to get accomplished for yourself. And for Hawaii, we've got the good, the bad, and the ugly. The good is real simple. For the Hawaii Lemon Law, basically the law is there, and that's certainly a lot better than not having it at all. Also, there are black letter presumptions of what a lemon motor vehicle can be, and we'll cover those in a minute, so you'll see exactly what those are, and it's good to know that at least they are there. Also, the law covers most motor vehicles, most cars, most light trucks, and also motorcycles now, too. And then we've got the bad, speaking of the good, bad, and the ugly. One of them is that the presumptions are rebuttable, and that means that you might get over the hump, but they might knock you back when they prove that, in fact, it isn't what you think it is. The second negative side of the Hawaii Lemon Law is that there really is no right to a court action. Under that law, you have to go all the way through it and all the way through the arbitration process that they have set up, and then only if things don't turn out right and you've preserved rights in a way that works can you then go to court. It isn't easy. And that's number three. It isn't easy to understand the law either, I might add, and it isn't easy to win a case under it either. Not as easy as you would think. And then the fourth aspect of what is the bad aspect of Hawaii's lemon vehicle law is that there are a number of debatable defenses that the manufacturer can raise to make it look like perhaps you really shouldn't win, even when you think you do have a lemon motor vehicle in Hawaii. And then there's the ugly. The ugly part of the Hawaii Lemon Law is, number one, a replacement vehicle, well, it's not going to be free, and it won't necessarily be a new vehicle either. The second one, you need an attorney. You can go through the process and cross your fingers and hope for the best, but the reality is that the best way to make sure you get what you need is with an attorney. And that brings up the third problem, and that is that there is no mandatory attorney fee recovery. So even though you may think that you need an attorney and you hire an attorney and the attorney helps you win your case under the lemon law in Hawaii, going through the process that they've set up, there's no guarantee that you won't have to, at the end of the day, pay for your own attorney too. And that's unfortunate because most lemon laws in the United States, in fact, do shift the attorney fees over to the manufacturer who built the lemon in the first place. And worst of all, the fourth side of the ugly side of Hawaii's lemon law is that you can settle your case in the midst of that lemon law process and still not get a check. In other words, there's no guarantee that at the end of the day, you'll get where you want to be. You may well end up having to get an attorney. As one client of ours recently discovered, when they settled their case after thinking they'd be able to get it resolved, and they thought it was all over and done with, and then 4 months later came back and hired us because they didn't get their check, the loan wasn't paid off, and now they were behind on the loan according to the bank too. We ended up getting that resolved for them and getting all of their money and getting them some extra money too. But it was unfortunate that the manufacturer didn't live up to their promises, even though the lemon law said they should. That's one of the ugly sides of the Hawaii Lemon Law. So that basically takes us here. The Hawaii Lemon Law is like a wonderful grandmother. The only problem is the Hawaii Lemon Law doesn't have any teeth. But let's talk about the vehicles that are covered by the Hawaii Lemon Law. Remember, first of all, that there is a three-part definition for coverage. To be qualified, a motor vehicle has to be a vehicle that was designed and intended and used on public roads. Secondly, it has to be a consumer vehicle. And also, the third part, there is a maximum gross vehicle weight of 10,000 pounds that is allowed too. If it's over 10,000 pounds, like an RV, a medium-sized RV or a heavy-duty truck or whatever, then the lemon law isn't going to cover it. If it's a vehicle that isn't really a consumer vehicle, such as a commercial truck and such, that won't cover it either. And the public road vehicle definition basically means that if you're talking about an ATV or a scooter or a bike or whatever, those are probably not going to be covered either. And we'll talk about those in a moment. So the typical vehicles that will be covered by the Hawaii Lemon Law: cars and trucks and vans and motorcycles, as long as the engine is 5 horsepower or more, and also small motorhomes, those that are underneath the 10,000-pound gross vehicle weight max. Demonstrator vehicles are also covered even when they are owned by the dealership and used for demonstrator purposes. Hawaii does have a couple of non-typical vehicle coverages that are allowed too, the kind of vehicles that typically would not be covered under many state lemon laws, but Hawaii creates an exception and pulls them in for coverage. One of those is business vehicles. Business vehicles can be covered if they are individually registered, meaning in the person's name and not the name of the business, and they are used in both business and consumer use. A combined use like that, even if the business use is on a big part of the vehicle, won't matter because you will still get lemon law coverage. Another kind of vehicle that can be covered by the lemon law in Hawaii, but normally would not be under many states, is a business-owned vehicle, one that is literally titled in the name of a business. It can still be covered if that business purchases only one vehicle a year and the vehicle is used in both business and consumer use. This is obviously intended for the small mom-and-pop type business, where in fact business owners have the business own the vehicle itself, which they typically use both in personal home use as well as in the business use that they're running. So that kind of a vehicle will also be covered under the lemon law in Hawaii. One of the really good things about the lemon law in Hawaii is that a notice is required to be given to the buyer of a new motor vehicle so that they understand that the lemon law is out there and that it might help them. For instance, it has to be plain language, and the existence of the state arbitration program, the SCAP, that has to be disclosed too. Also, this notice has to give them a basic notice of their consumer rights and telling them that they are required to give advance written notice to the manufacturer if they think they've got a lemon, and telling them what the name and address is for that manufacturer too, so that you know where in the world to mail your notice to. All lemon laws generally have what they call a presumption period or a lemon law rights period, and Hawaii is no different on that. However, the one aspect that is a little unusual with Hawaii is that they give you 24 months after the original consumer delivery or 24,000 miles of operation. So what that means is that if you buy the vehicle inside that time frame and your defects develop, then the lemon law can still cover you even though you bought a used vehicle. So that warranty time frame is extremely important. Also, critical to everything for a lemon law use is the fact that this lemon law rights period can apply to you. Remember, in Hawaii, it's 2 years or 24,000 miles of operation on the vehicle. Every state lemon law has what they call a nonconformity, which essentially is what they use to talk about a defect or a condition in the vehicle that isn't the way it should be. Almost all of these nonconformity definitions in lemon laws around the United States are similar to what Hawaii uses. It requires that the problem or the defect or condition substantially impairs the use or the market value or the safety of the vehicle. Note, however, that it is sort of an objective test. It is not the use or market value or safety as far as the consumer is concerned. It's not impairing the use of it to the consumer, but just simply impairing it in general. That means it's an objective test, not necessarily what the consumer thinks, but what a reasonable person might think when it comes to whether or not that particular defect impairs the use or the market value or the safety of the vehicle. And when it comes to market value, it's not the value of the vehicle intrinsically, but a market value, a willing buyer and a willing seller kind of a scenario. What do they think it's really worth? But once again, it's a reasonable person and not merely just what the consumer owner of the vehicle might be thinking. One of the unique aspects of the lemon law in Hawaii is that there's a specific definition for what is meant by the phrase substantial impairment. And in Hawaii, it specifically means that the vehicle is unfit for normal use or unreliable for normal use, or it's unsafe for normal use. Any of those three things can trigger substantial impairment under the Lemon Law in Hawaii. The fourth one is that when it comes to the market value, a substantial impairment of that means significantly diminishing the value of the vehicle. Now, how much is significant? Well, that's a bit of a judgment call. It might be a little bit, it might be a whole lot. In most cases, it needs to be a pretty significant percentage, a pretty big chunk of the market value itself. If you're talking about a vehicle that, say, is sticker priced at $30,000, what is a significant diminishment of value of that vehicle in the marketplace? Well, probably something in the vicinity of $5,000 would get it. $3,000 or $4,000 might not. 7 or 8 more likely would. It becomes a matter of numbers, as you can see. So that can become important. Like many lemon laws around the United States, Hawaii has two primary sections that create certain obligations, what is called sometimes the repair it or buy it back or replace it obligation. What's important to note is that under Hawaii's law, in reality, these two different subsections give different legal rights to the owner. The first one, subsection 3A, it only creates a repair obligation, which means that under that part of the statute, the manufacturer is obligated to repair the defects that exist in a motor vehicle under the lemon law presumption time frame. Question arises, what if the manufacturer refuses? What if they just simply say that they're not going to fix it because they don't think it's a defect or whatever? Well, that makes it a very debatable situation, but it might also create a waiver of the presumptions that exist under the next section that we're going to talk about, because it is that next section, 3B, that creates by law the requirement for the manufacturer to buy back a vehicle or else replace it. That obligation does not exist under Section 3A. Under that section, it's just a requirement to fix it. Under 3B, if they meet any presumption or if they fail to fix the vehicle within a reasonable amount of time, etc., then you can trigger that section's rights. And under that section, 3B, the consumer has a right to either a buyback or a replacement of the vehicle. Hawaii also has a couple of unique aspects to its lemon law presumption period, the 2 years and 24,000 miles. The definition of a lemon, the presumptions there, the first one is the same defect. If the same defect arises 3 times and it doesn't get fixed by the end of the 3rd time, then the vehicle is presumed to be a lemon. Sort of a 3 strikes and you're out rule. The documented attempts to repair it are necessary, though. It's not enough for you to be able to say as a consumer, I went in and I came out and they didn't get it fixed. It needs to be documented, which is why getting the repair order paperwork is critical to winning a case. Also, on the second repair attempt, by law, the dealer is required to give notice to the manufacturer that the vehicle is back in again for that second repair, and also at the point of 20 days out of service. So that can help the consumer too, because it puts the manufacturer on notice. The second presumption that exists under the Hawaiian lemon law is if you have a deadly defect in the vehicle, then the manufacturer's dealership only gets one chance to fix it, and that's it. If it isn't fixed on the first attempt and that problem rearises, then that is a deadly defect that qualifies you for lemon law relief. There's a third definition of what a lemon can be under the lemon law in Hawaii, and that's 30 business days out of service. That's the max. You roll over to day 31, it's a lemon. And note, however, that under the deadly defect definition, it has to be one defect that triggers it. Under the 3 strikes and you're out rule, it has to be the same defect that triggers it. But when you get to the 30 days out of service, you can take some defects here and some defects over there and add them all up, because it has nothing to do with the quantity of defects. It has everything to do with the quantity of business days that the vehicle is out of service. So what are some of the arguments that you can hear a manufacturer argue to avoid having to buy back your lemon car or your lemon truck? Well, one of the primary ones you're going to hear is they're going to say that the defects did not occur within 2 years or 24,000 miles. Well, it's important for the consumer to point out and argue